So jurors who are just scrolling to look up their family members, perhaps to make a call, are getting these media blasts to their phone. The other thing we had, Your Honor, was a protester outside who initially related to this case. It appeared she was related to another case in another courtroom, but then she posted on Justice for Layla and talked about the testimonies that have been, she had collected as she stood there, but tagged herself as at Justice for Layla Daniel.
Can I just stop you for a second? It occurs to me that perhaps we should be giving the jurors a recess this time. Sure. Okay.
If you would just knock on the door, please, and let them know that they are on recess for 15 minutes and ask them to exit the jury deliberation.
Yes. You want them in the hall and let them,
That's fine. You just sit down in the hall over here.
Judge, at this time, I would tender Defendant's Exhibit B, which is the posting of the woman who was protesting in front of the courthouse. She says, the rain ended a long day of protesting. I was overwhelmed by the honks, waves, and people who took their time to stop and talk to me. I pray for my little girl, all families and children experiencing this tragic injustice, and at Justice for Layla Daniel, exclamation mark. This time I would tender Defendant's Exhibit B, having shown it to the state.
Okay. Okay.
Your Honor, I would refer the court to the case of, Supreme Court case of Shepard versus Maxwell, which is 384 U.S. 333 in 1966. And the court in the Supreme Court decision looked at the amount of times there was an article, the amount of times there was reference, and to that point, I am tendering Defendants C to illustrate the fact that there are followers to the streaming, and in just a short period of time, 100 people were viewing the live stream. And so I would tender that into the record.
Okay. No objection. Submit.
Your Honor, additionally, what's been happening is the media has been covering the breaks, and the jurors on break. The court holds a conference up here in open court, and they report exactly what's been said and what's been denied and what's been accepted, and they publish that, and that is visible to all jurors. Henry Herald lies on benches. It's at the entrance of the courthouse when you come in. It's in shops and things out on the square. And to that effect, I would tender Defendant's Exhibit D, which illustrates this fact. That basically, anything we take up outside the presence of the jury is blasted to the jury in a subsequent article or TV.
All right. Submit.
Your Honor, the court has repeatedly told the press, and we have repeatedly told the press, that they cannot take pictures when the court is not on the bench. They continue to do that, and in fact publish such a picture on Defendant's Exhibit E, which we would tender as illustrative of that violation that occurs repeatedly despite the court's engagement of the media not to publish photographs or take photographs of what goes on when the court is not present. The mics are open and they hear what we say at council table, and so I would tender Defendant's Exhibit E to that effect.
Any objection to E?
No objection, although I think what it shows is a photograph that was being taken on break. I don't know if it goes as far as having anything to do with private discussions that were had at council table.
All right.
Your Honor, what it shows is a picture taken in the courtroom with the judge not present. There is also the Shepard versus Maxwell looks at whether or not what the media has provided has been erroneous or false, and they have repeatedly, starting with the notion that Layla choked on a chicken bone, they have repeatedly relayed the wrong information. I would tender Defendant's Exhibit F to illustrate that fact. And this is a situation where the article says on the last phone call with her girls, Rosenbaum told Clendenian that Layla was not going to talk. She doesn't feel good today. That was not what was in the tape. It was not what was in any testimony whatsoever. She did, in fact, speak to Layla. We sat and listened to it. So it's just false information. And so I would tender Defense 5F to that effect.
Admitted.
We have had purposeful contact by a member of the press with a reporter, prefaced with the notion that I know I'm not supposed to talk to you, but the conversation ensued. And now we hear that the conversation may have included comings and goings, not just a one-time encounter, but going into. I'm relaying what Mr. Chase and I discussed earlier. There was a conversation, as I understand it, between Mr. Chase.
Sure, and Judge, if we need to, we can perfect the record. Investigator Jackson with my office spoke to the AJC reporter yesterday after this all came about. I know Ms. Moll was in the hallway as well when that conversation happened. And then after the state received this email last night, I asked her to reach out instead of myself. I asked her to reach out for clarification on what this Stevens meant by this particular statement in her email. And Investigator Jackson, I think at this point, since we're doing this morning, it might be best for her to convey to the court what was said to her both outside the courtroom and...
As an officer of the court, can you restate what she said?
I want to make sure I get it correct. So if I can just, if I can just ask her again, because I don't want to summarize something that was incorrect.
I understand.
In fact, she should be able to do that there. Judge, this is what Ms. Stevens conveyed to Investigator Jackson both yesterday in the hallway when Ms. Moll was present when they actually had that conversation, as well as last night, was that Ms. Stevens said that she walked up, and this was at the taco restaurant that's right there on the square. She walked up, she said, "How's it going?" as a pleasantry. What she conveyed to us was that it wasn't meant to actually inquire as a reporter saying, "What's the status?" She said it in a way that was more of a, "How's it going?" Like someone might say, "Hi," or "How you doing?" or something like that. The juror stated then it's going to be a while, and Ms. Stevens conveyed that she then walked inside the restaurant. When she came back out, she says that he engaged her by talking again and just said there's a lot of evidence to sort through. And she said that at that point she walked away, and that was the end of the conversation.
That's what I was referring to. That was conveyed to me early this morning. My conversation, I did not participate in the conversation with Investigator Jackson and Ms. Stevens. I came in late in the game and let them finish the conversation, then had my own conversation with Ms. Stevens, where she told me, of course, a different story. My concern with regards to Ms. Stevens doesn't end with her tainting the jury. She further wrote an article on July 30th that basically addressed what the court would not, when the court would not give a clarification about the legal definition of parties to a crime, and the court said, as quoted by the reporter, my first response is that we cannot clarify this. She then wrote a fourth note was sent out late Monday afternoon about counts 36 and 37, asking whether the charge of changes applied to the right, left, or either leg. Again, Judge Amaro said, my first response is, again, we can't provide any further clarification and leave it at that. She then does not leave it at that, but says count 36 is aggravated assault and count 37 is child cruelty in the first degree, which are related to injuries to Layla Daniels' inner thigh. There's absolutely no evidence whatsoever that this is A, correct, B, appropriate to be relayed to the public at large, given that we have a jury that is out there that has its phones and that is non-sequestered at any time. To provide that information is careless, it's wanton, and it has the opportunity of totally tainting this jury. I would tender in that regard Defendant's Exhibit G into the record.
No objection.
Submitted.
And it bears noting, Your Honor, that Ms. Alexis Stevens is on the website as a member of Justice for Layla. So her impartiality is further in question. I would also note, Your Honor, that we have had a deputy who has sat in both in uniform and out of uniform in the courtroom and has then gone on Justice for Layla and given encouragement and to the family of Layla and Millie, saying, hope to see you. And they have said, June Taylor, I need a smiley face. And she has gone on and gotten on the website and talked about what has gone on, saying, sorry I couldn't stay, I'm upstairs in courtroom C, hope judge rules for y'all. And that would be Defendant's Exhibit H, and I would tender that into the record.
This is separate and apart from any media concern.
It is. It's the buildup. It's not just one thing. These things have not been sufficient on their own, small things like that. But then when you sit back and you have contact with the jury, it's like it's escalating. It goes from showing people in the jury box, showing us during breaks, to now contacting the jurors themselves and talking to the jurors themselves. So
Your position is that Ms. Taylor has somehow had contact with the jurors?
No, I'm just saying.
Because my understanding is that she has not. My understanding is that Bobby has been our bailiff.
Yes, I'm not making that representation. What I was talking about is that we have started out with the fact that the media has violated Rule 22. We've now reached up to contacting jurors, and in between we have all these, the lady in the poster, the deputy who's typing on Justice for Layla, and who is available to, which is available to all to see.
Is there anything else?
Yes, Your Honor. I have 4 more exhibits. Your Honor, additionally, we've had the state, it's been brought to my attention that the state, the panel that reviews the child death and fatality cases was staffed by Ashley Wilcott, who is a pro tem juvenile court judge. She staffed the panel and then showed up on the show that is filming this case today, Law&Crime, Crime and Law, something to that effect.
It seems like we're getting a little far afield.
Well, it's just all the different things that are happening, because this person then got on the show and said that these people are guilty, these people are responsible for what they did, and as a judge, she shouldn't be saying that.
Next.
We would tender aye into the record.
Ayes admitted.
Your Honor, we would tender into the record Defendant's Exhibit K, which basically is what you can Google online. You Google Jennifer Rosenbaum, and all of these articles show up, available for the jury to see. And we would tender K into the record.
Admitted.
And that's what I have, Your Honor. We would ask the court to grant us a mistrial. There's been just too much information that was unduly extensive, factually incorrect, inflammatory, and prejudicial to the defendants. And for that reason, and for today's contact with the juror and contact with the state, where they clearly, the reporter showed their bias, we are asking for mistrial.
Right. And do you have a copy of that Schefter versus Maxwell case?
I did get it printed up. I just looked it up moments ago.
All right. I'll hear from the state.
Judge, clearly the state would object to the mistrial. What Ms. Malkus failed to show is that any of the jurors have seen any of this pretrial publicity, have seen any of these things, and I'll just go through her number. Defense Exhibit A, which she referred to as a news alert that comes up on everyone's phone, that assumes that a person has WSB downloaded on their phone, and it assumes that the people also, the person who has the phone has their notifications turned on, wanting every single time there's a news notification. There has been absolutely no indication from this jury that they have seen any of the pretrial publicity, seen any of the publicity during the trial itself. And in fact, when there was a question yesterday, from what the juror said, they all knew that if there was any sort of improper contact, they needed to bring it to the court's attention. That's the jury we have here. They are taking it seriously. This court has given them the admonitions on numerous occasions. The court admonished them again yesterday, simply saying that how important the integrity of this trial was. All the jurors nodded in unison. They understand the importance of abiding by their duty here. Regarding the protester in front of the courthouse, that protester has a First Amendment right. There has been no indication whatsoever that that has influenced the jury in any way, shape, or form. Regarding the media coverage, while yes, there has been media coverage in this case, again, there's been no indication that the jurors have seen any of that media coverage that has impacted them in any way. It's simply the defense grasping at straws, attempting to say that there is a possibility out there somewhere that if the jurors happen to come across some news coverage, then they might be exposed to it. But there has been absolutely no showing that that is the case in this case. Regarding the deputy who sat in the courtroom, I think the court was correct that she has had no contact that anyone is aware of with the jury. And again, Just because she's a deputy doesn't mean she also doesn't have a First Amendment right. As far as the Ashley Wilcott, I don't even know if I need to address that. It just seems pretty far-fetched to even think how that would be relevant in this particular case. That is a separate and distinct issue from the juror issue. And when I spoke to Ms. Mull this morning, she indicated to me that it was that the removal of the juror would be the appropriate remedy in this particular case. And I would say that the state is not saying that he lied. But there appears to be some kind of disagreement as far as what he said and as far as what the reporter said. But I would note for the record that this juror did self-report to the court by sending a note to the court, and I think that does speak volumes.
And I would assume that everything that this reporter has said to your investigator is true, and the extent of what this contact was basically a pleasantry.
Yes.
And then there's a lot of evidence to go through.
Correct. And there has been nothing, and unless if the defense has anything different, I invite them to share that, but there has been nothing substantive. Even when the AJC reporter was in court yesterday, the court specifically asked her, was anything substantive discussed? And the answer was no. The juror also said that there was nothing substantive that was discussed. The disagreement appears to be to the extent of which non-substantive things were discussed, pleasantry type things were discussed. At no point was there any discussion about what they were talking about. There was no discussion about Ms. Stevens providing any sort of information to the juror. There was no discussion about anything that they were talking about in the jury room, simply that there's a lot of evidence to sort through. There's almost 700 exhibits in this particular case, and that would be the extent of what was discussed. There was nothing substantive. Regardless of which statement you were looking at, neither of them discussed anything substantive. But out of an abundance of caution, I think it would be best to remove the juror, and when we spoke to defense this morning, they agreed with that.
If the juror is removed out of an abundance of caution, perhaps the juror should be shifted to hold status. In other words, not excused. And continue to be kept separate from the other jurors. Rather than dismissed in toto, so to speak.
I have no problem with that.
And the other piece of this is that we probably need to address some sequestration, either limited sequestration or complete sequestration at this point. Did the parties disagree?
No, I think sequestration at this point would be in everyone's best interest.
Okay. Preserve the record. I am denying the motion for mistrial, and we are going to proceed to implement procedures to sequester the jury. I think the first step will be to have the jurors together during breaks in custody or supervision of the sheriff's deputy. And at lunch, we're going to have the jurors taken to lunch together under the supervision of the sheriff's deputy and return together at a specific time. And the deputy will be instructed to take them to a place that is free of distractions, and hopefully a little farther away from the square than the taco shop. I believe that it's a closer call as to whether or not we should replace this juror, because it does not appear as though the juror has commented on anything substantive. But if the parties are in agreement that this juror should be substituted, then that's what we'll do.
The state is fine with that, Judge.
All right, and then what that would mean is that we shift juror number, is it 76? Make sure that we have that right. Both parties agree that it's juror number 76.
Yes, Judge, and if we could just get the defense on the record as far as whether they agree with replacing that juror with the alternate.
If our motion for mistrial is denied, then yes, we agree the very least that we should do is to replace the juror.
Okay, then we'll replace that juror and we'll shift him to alt status, keep him a part of the group until the conclusion of this proceeding. And we'll start with the limited sequestration on breaks and at lunch. And then if we get to the end of the day, we will consider whether to also have them go and get a bag and put them up in a hotel. Okay.
Well, we have to consider that they would have to give up their phones at least during deliberations, if not any other time. I mean, that just seems like it's, in my experience, we've had trouble with that before.
Well, at the end of the day, what's required is that they comply with the court's instruction. I'm comfortable with either allowing them to have their phones or not allowing them to have their phones. If the parties agree out of an abundance of caution that we should ask them to turn over their phones to the sheriff's deputies, then that's something that we can do.
I think at this point, for taking all the other measures, it would make no sense.
I do think that it would it may help, and because it may help, that's what we'll do. So, all right. The next thing that we're going to have to do is bring the juror in, number 76, and tell him that he is being removed and shifted to alt status. Okay. Then juror number 95 will find its way back into the jury deliberation room, and all of the jurors will have to be instructed to begin the deliberations anew.
That is correct. And Judge, if I could just also note for the record that Juror 95 has been present in the courtroom whenever there has been a question or whenever, since deliberations have begun, he's been kept separate while they're actually deliberating, but whenever there was a question or some matter where the court was addressing the jury as a whole, he as well as the other alternate were also present in the jury box.
That's always the practice of the court, and that's true. Anything else?
No, I'll email you the case.
Okay. I'm inclined to, it's a 1966 case. I think that the court has discretion in this regard, and based on my experience, and so, again, the motion is denied, irrespective of the holding of that particular case.
Thank you, Judge.
Let's go ahead and bring in juror number 76, Tyler Jordan Moreland. Okay. Mr. Moreland, welcome back. Yes, sir. Out of an abundance of caution, of discussing this issue more thoroughly with the counsel for the parties, we've decided to shift you to alt status. Okay. And so you'll be required to stay, and you'll not be excused, but you're shifted to alt status. Do you understand? Yes, sir. Okay. Thank you. Yes, sir. And if you would please have Mr. Just step up and call, please. Next, let's have the all of the jurors return to the courtroom.
Yes.
All of the jurors should return to the courtroom in the jury box.
Except for 76.
No, even 76. Even 76.
Yes.
Two alternates.
We need everybody.
This just was the two alternates.
I'm sorry, I'm not hearing you.
The two alternates.
I need everybody.
Yes.
Okay. Ladies and gentlemen of the jury, we've had a development. Juror number 76 is being shifted to alt status, and juror number 95 is being shifted onto the jury for the purposes of deliberation. And as a result of that change, it is necessary and required that the jury begin their deliberation anew. All right, does everybody understand? Okay, and so what I'm going to do is ask that the reconstituted jury be delivered to the jury holding room at this time. Thank you. If there's nothing else, then we are office. Let's go ahead and have Bobby do that, okay? Please tell Bobby that he needs to collect everybody's phones. Okay, and John, what we're going to need to do is we're instituting a new protocol as it relates to jury handling the rest of the day during the 15-minute break that they take. You're going to be required to keep them separate. In other words, you're not free to go about on their own. They're sequestered in your custody. And also during the lunch break, they're going to be sequestered in your custody. And if you would please take them to a place that's sort of quiet and away from the square, and be sure that no one is speaking to them or contacting them. All right? And we're recessed.